Hi, this is Patrick Conroy, and welcome to Chapter 7, Civil Litigation Resolution. There's a lot of meat in this chapter, but I'm going to try to do the presentation in one go. If it's too long for you, press pause. Okay, so civil litigation resolution, what are we talking about? It might help put it in perspective if I give an example. Say you are walking to your car. You know, you've been shopping at Lakeside Shopping Center, got your bags, you walk into your car, which is parked in the parking lot, and you get hit by another car. Didn't see you, whatever. You are left with all sorts of injuries, medical bills. You may not be able to work for a while, so you need money for that. You might need to pay someone to take care of your child because you can't do it, all sorts of bills. Civil litigation is a way of trying to get paid back for all that you've been through and to help cover those bills. That's one example of civil litigation. Or it can be a contract dispute, all sorts of things. But for these purposes, for today, we're going to talk about his personal injury. You have been personally injured. You know, maybe the driver broke some law and they're going to jail, but that still doesn't get you any money. And you really need money. So you go, you sue somebody. That's civil litigation. So in this chapter, we're going to learn how to explain the role of a paralegal in the litigation process, describe the type of civil litigation pleadings and their purposes, explain the purpose of discovery in the litigation process, and explain the use of pretrial motions and settlement conferences. And then describe the steps in a trial, and describe how a case is appealed and what decisions be rendered by an appellate court. Okay, civil litigation, basic definition. Civil litigation involves legal disputes between parties seeking a remedy for a civil wrong or to enforce a contract. So it's not criminal. This is civil, between two parties, not between the state and a defendant. Litigation can be a fast-paced process with sudden deadlines and demands imposed by changing trial strategy and the availability of witnesses in changing trial strategy. Changing trial schedules and strategy. A paralegal must have a basic knowledge of the law and of how the courts function. Some civil litigation areas require specialized knowledge. For instance, if it was like medical dispute. Because of their knowledge of a case, paralegals can be indispensable in the preparation of lawyer-client meetings, discovery, depositions, and settlement conferences. Big role. Okay. So the process. This requires the assembly of information and evidence, analysis of facts and law, preparation of material for trial presentation, and post-trial appeals and execution of judgment. You're going to have to find evidence to support your claim that the shopping center was at fault, because the you can sue the driver of the car, but they're only going to have so much money, and maybe that doesn't cover all your expenses. So maybe you can sue other parties, the car manufacturer. Maybe the problem was with the car. Shopping center. Maybe they were negligent in the repair of the parking lot. So you're going to have to, get witness statements, all types of information that you can find, and the preparation material for trial presentation. Okay, you have to understand the client's views and values. What's important to them? Maybe they're not as interested in money as they are as, they might be more interested in getting quickly than getting the greatest amount of money. Paralegals are often responsible for managing client relationships, including updates to clients on litigation status. You're going to bill the client at a much lesser rate if you call to say that the trial has been delayed than if the attorney does. Paralegals are often tasked with interviewing, collecting documents, and preparing trial materials. At trial, paralegals provide a variety of services, including determining the availability of electronic equipment in the courtroom, ensuring witnesses arrive on time, and handling exhibits in the trial method. Corporate paralegals may manage a relationship with outside counsel. That means that you're working as a paralegal for the shopping center, but they might have also hired a law firm, an outside law firm, to handle this case. So you're going to have to be working as intermediary between the two. The litigation support manager may coordinate technology for the entire firm, including the education of non-legally trained staff and the ethical obligations of the legal professional. So, you're going to court, you're going to have all sorts of electronic presentations, videos, documents, PowerPoints, all being presented to the jury or the judge. Well, if that's the case, you want to make sure that the technology in that courtroom is up to speed, whether you have to bring your own stuff, whether it's got internet, wireless internet, whether you have to download stuff, all of these sorts of things. Pleadings, that's how things start off. Pleadings are the documents filed with the court to commence a lawsuit or respond to a complaint. Now, paralegals must be aware of both statute of limitations, the time in which a litigation must commence, which means like you have like 1 year after the accident to file a claim by putting in pleadings. Pleadings are put into the court. And the time limits imposed by the court rules in which responses and other documents can be filed. Court rules require an attorney to sign all documents unless the litigation involves pro se litigant. Pro se litigant is someone representing themselves. So while you might prepare the documents, the attorney needs to sign them. So you have to make sure you get them, because they're supposed to be looking over your work and making sure it's correct. Some courts have a traditional filing where the documents are delivered to the court, but more and more courts are using electronic filing where documents are delivered to the court electronically. It's much more efficient, it's easier, and there's an automatic timestamp on them. Make sure that they will be arrived in time. And the first is the complaint, saying, hey, we're suing the shopping center because of the negligence in their parking lot resulting in this injury. After the complaint is filed, is served on the defendants, typically through a summons that require the defendants to appear and answer the complaint. If the defendant fails to respond, the court can order default judgment. In which case, that's easy. But they're going to respond. Okay, the plaintiff files the initial pleading. The complaint, that's where's the cause of action being stated in general terms to give the defendant notice of the allegation. As I said before, such and such sustained these injuries, and it was because of the negligence of the upkeep of the parking lot. Fact pleadings require a more detailed allegation or description of the basis for the action. That's when you will go into details about lighting, the asphalt, the signage, all those sorts of things. The fact pleading. Filing fees are paid at the time of the filing of the complaint unless waived by the court. Sometimes the court will waive it if the person who's making the lawsuit has a clear case and they don't have much money. Electronic filing is very typical of federal courts. And states are increasingly using electronic filing as well. In Louisiana, we've had that. Always double check the local rules for specific filing requirements. Then after that, the complaint must be served on the defendant to start the response time period. So it's not just that you filed it, but the defendant has been summoned and is aware of the complaint. That's when the clock starts ticking to them. The defendant files a response to pleading, admits or denies the allegation of the complaint. Parking lot's in perfect order. We have all the signs, we have the lighting. In addition, defendant can allege the plaintiff, in this case, you, committed wrongs against the defendant. You know, like the reason why there wasn't light was because this person, shot out the light bulb. And they owe us for that light bulb. And then the defendant files a response to pleadings. And then there's intervention and consolidation of all the claims. And this allows an individual who has an interest in the outcome to step in and become part of the lawsuit. So maybe at this point, the person who hit you files a lawsuit, claiming that their car was messed up because of the faulty lighting or whatever. They can join the lawsuit against the shoppers. Discovery is used to obtain evidence to assist during trial. So this is, you sort of conduct an investigation and look for evidence to back up your claim. And this could be paper or electronically stored information. So you might be going through all sorts of past cases of injuries in that parking lot. You might be looking at electronically stored information, which could include emails from the maintenance department saying, hey, we really need to fix this. Litigation holds should be requested when there is concern that opposing parties may destroy evidence related to the litigation. So, you have a feeling that this issue was known by the shopping center because the maintenance people sent them emails. So you can, request that there be a litigation hold to make sure that those emails don't get destroyed. Parties also have an obligation to preserve evidence. Discovery should eliminate surprises during trial. The whole thing is, it adds a lot of drama for TV shows to have like a surprise. But really, the court doesn't want that. They want everything laid out beforehand so that they can make the best decision based on the facts. And that's surprising one side by the other before they have a chance to figure out what you're doing. Often, the discovery process results in settlements as it allows both sides to evaluate their sides more fully. Looking through these records, turning to the shopping center, they have a very strong case. Maybe you should offer them money instead of us going to court. That's a seven. Federal Rule of Civil Procedure 26A and its state counterparts require attorneys to disclose evidence without waiting for a formal request. You can have an expert or other witnesses, they must be listed, and any reports that they have made are provided. The dispositions and interrogatories, which are sort of interviews, all of that should be made to both sides. Counsel might request an independent medical examination of the plaintiff in a personal injury suit. Maybe this person's saying that they're unable to work. We're going to have them go to our doctor to see if the case is really true. Either side can request admissions, asking that certain facts or legal issues be admitted as true so that the scope of the trial can be narrowed down. E-discovery covers the discovery of electronically stored information such as emails, e-contracts, and other electronic documents, cell phones, text messages, all of those. Most federal and state courts have adopted rules that permit the discovery of these electronic sources of information, which is why we often it's best not to put anything in written form that you would not want to disclose publicly. Parties are not permitted to destroy or delete documents or evidence that is relevant to pending lawsuits. And if you do that, that can open you up to criminal liability. Okay, so we've done the pleadings, we've done the complaint, we've done the response, going through discovery. Then we have some pre-trial motions. And this is a way to get rid of all or part of the lawsuit prior to trial. Motion to dismiss. That's when party being sued said, hey, with the plaintiff's complaint fails to state a claim for which relief can be ignored. Yes, there was an injury, but they haven't really said it was our fault. You know, there's no claim about it. Or yes, this happened. Yes, the parking lot was in bad shape, but the person wasn't injured. Judgment on the pleadings. If all the facts, if everything the plaintiff says is true, even then, they can say you could win the lawsuit. I'm not just your sweet is the way it's done. It's sort of like, it's more like, okay, let's say everything they say is true. They still haven't proven a case, so it should be dismissed. Or you can say, hey, just look at these pleadings, they prove it, beyond the doubt. Summary judgment, sometimes there are no factual disputes to the issue, but there is an issue of what law should be applied and how it should be applied. So you can ask for summary judgment based on there was no the law that they are trying to sue under is the right law. This is the right law. They have no settlement conferences. Court rules all the judges, the direct parties and their attorneys to a pre-trial hearing. And the hope is that the settlement can be reached before you go into the court. Pre-trial conferences establish deadlines for discovery and motions to be submitted. One party might be trying to drag out the process, so the other party is left financially ruined, and maybe we're taking a quick settlement. Don't want to do that. Some courts require parties to attend settlement conferences, alternative dispute resolution prior to the start of the trial. Parties who would to the case can request either a bench trial. That's when the judge is the one who makes all the decision, and they hear the evidence, they make the ruling, or a jury trial. And that's what you see on TV, and that's a group of individuals selected by the sides to hear the case. In this case, it's not whether someone's guilty or not guilty, whether they are liable or not. If a jury is selected, the attorneys will conduct what's called voir dire. And that's when they ask the prospective jurors on their views and opinions before being asked to render a decision. So if you can tell right from the get-go that someone's not going to rule in your favor, you might get rid of them. Maybe they knew someone who was also interested in the same parking lot. Maybe they work in that shopping center. After the jury is seated, the plaintiff presents their case, and then the defendants present their case. Then the defendant comes in and tries to rule, but plaintiff's evidence to provide the points. So it begins with the plaintiff, in which case you, presenting your case, then the shopping center, then the defense can rebut the things that the plaintiff said. Then the plaintiff has an opportunity to rebut, and the defendant can then call additional witnesses and introduce other evidence during the rejoinder. After the conclusion, the parties can present closing arguments, which remind the juries what evidence was presented. This is this is an art form. You want to, make them forget about everything that the other side said and just focus on what you said. Because here, what you said will mean that you win. Then the judge gives the jury instructions about what law they need to apply in deciding the case and start their deliberation. After the jury reaches the judgment, the other party may appeal the decision or request the court to reduce the award amount. If that doesn't work, if you don't like the outcome, either party can appeal the trial court's decision. But you can't just have another trial. It's very limited in what you can appeal. And the parties are requested to be briefed, providing legal authority that they could support the contention that the trial court erred in this decision. So it's not the facts of the case that are heard on appeal, it's how the law was applied. And you're saying that the law was applied incorrectly. The judge's instructions, the jury would conclude. When the judge refused to let in evidence of appealing that decision. In some appellate cases are based on the written briefs that are presented. In some cases require oral arguments. Sometimes you can just just present your appeal in a written form. Judges look it over and make their decision. Some cases require oral arguments. There's no jury in the appeals. And the appeal court can affirm, which is uphold the decision of the other court, say, hey, we're sticking by that law. Reverse and find that the lower court erred in its decision, or it can remand and request the lower court to take additional actions consistent with its decision. So it might be like, oh, we're going to remand you and send this back to the court, and this time you are going to let this evidence that you didn't follow in. Okay, so that wraps up this chapter, and good luck with the assignments, and hope you have a good week.